Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I wanted to comment on the $50 million Starbucks hot tea, hot coffee verdict that came down a few weeks ago. So the interesting thing about this case is the settlement history of how it all transpired, right? Some people might think $50 million, that's so much money. But Starbucks had many opportunities to settle the case for less. What happened was the lawyer representing Michael Garcia sent a settlement opportunity letter and gave Starbucks the opportunity, the chance, and the choice to either accept or reject a settlement. And that settlement in the letter was for $19 million. And at that point, Starbucks wrote back, the council got involved, and there were some negotiations. And there was talk of settling it for less, for 13 million, or maybe it was 13.5 million. And Michael and his lawyer at that point said, yes, we will do that. We will settle for 13 million. But Starbucks then went back to the corporate and they said, you know what? We don't want to do that because they had what's known as a self-insured retention, SIR. That's kind of like a deductible. And so the deductible, I think, was $5 million. And so Starbucks would have to pay $5 million out of their own pocket. And then after that, the insurance would kick in. But Starbucks, their corporate people in corporate said, you know, that's too much. We don't want to pay $5 million out of pocket. Let's offer 2 million or 3 million and no more than that. So then Michael and his lawyers said, well, okay, let's go to trial then. So then what they had in this case was known as a bifurcated trial. Bifurcated meaning there was liability. And then if they lost liability, it would be over. But if they win liability, then there's another trial with the same jury about damages. And damages answers the question, well, what are all your harms and losses, economic, non-economic, what is this all worth? And liability obviously answers the question, well, who is at fault? So they start the liability trial. It was a fairly quick trial, but Starbucks argued in the liability trial that it was not their fault, that once they hand the tray with the hot coffee to the customer, as soon as, you know, the tray and the hot coffee, the hot tea leaves their hands, it's no longer their responsibility. That was their position. And they said Michael had a dog in the car, the dog might have hit the tray, all these, like, you know, basically throwing things up against the wall to see what sticks. But all of these were nonsensical arguments because they had the video. And the video showed clearly, like, you take a lid, you put it on one cup, it goes whoosh, and it's secure. You do that to the second cup, and the barista was doing it. And these were medicine balls. I think they were 185 degrees, and, you know, water boils at 212 degrees, so they're super hot. And the third one, she never made the whoosh. She just kind of left it there, and it wasn't even, and the entire cup also was not in the tray. So the lid's not really on very well, and it's not in the tray. There's no whooshing sound. So when she hands the tray, of course, the cup that's not in the tray securely is just going to flip over and fall, and that's what happened onto his, he's in the car wearing shorts, and it falls onto his lap, and it burns his genitals and his thighs, really severe burns. So at this point, they win liability, right? And then they say, at this point, Starbucks says, okay, now we know we're going to damages, let's do a high-low. Now, a high-low, what that means is the low was going to be 10 million. And you can propose any, as long as both parties agree, right? The plaintiff who's suing and the defendant, as long as they agree, you could make any kind of high, any kind of low. And that basically means that if they get 0, well, they still get 10 million. That was the low. And the high was 20 million. So, for example, if they get, you know, 100 million, well, they're still going to get the 20 million because that's the high. So it's basically you set parameters and then you do the trial. And depending on what the result is, if it's 0 or if it's under 10 million, you still get 10 million. If you get between 10 and 20, well, you get that number. If you get more than 20, well, you just get 20. And then the plaintiff's lawyer said, no, I don't want to do a high-low. And, you know, that was kind of, you know, a risky because that's guaranteed money between 10 and 20. That's a lot of money. But he, you know, he wanted to send a message, and he thought that, you know, this is not only about the money, but it's also about the fact that he wanted to see some change and he wanted to see some accountability. And so at that point, Starbucks said, we're going to offer you 30 million once they rejected the high-low. So the plaintiff's attorney spoke with his client and they said, you know what, we will accept the 30 million, but on two conditions. Number one, the settlement cannot be confidential. We want people to know that this happened. And number two, I want you to send an email to like all the Starbucks, all over the country, and just kind of tell them, hey, just double check your lids, because if you don't double check the lids, if you don't double check the cups going into the holder, people could get burned. You're literally handing people a burn and injuring people. And so they talked again to corporate, and somebody in corporate said, no, we don't want to agree to that. We're not going to send emails. No way. So they said, okay. And then they did the damages trial, and then the result in the damages trial was actually $50 million. There were 9 out of 12 jurors that agreed to the $50 million, and the 3 that held out actually wanted to give $125 million, because in the closing argument, the lawyer said that the amount should be in a range between 75 to 125. And so 3 people on the jury wanted to give the full 125, but the jury agreed to 50, and with interest going back to, I believe, the 998 that they did, the settlement from before, because the case was going on for many years, it was actually, I believe, 61 or 62 million total that they owed. So it just goes to show that it's not really, a lot of the times the insurance companies like to spin these kind of cases and say, look, the lawyer's getting these nuclear verdicts, but wait a minute, you had opportunities all along to settle this case for less, and you chose not to. And that's why this happened. So it's not always about the plaintiff being greedy or the plaintiff trying to, take a nuclear verdict. Sometimes it's about the defendant having frivolous, ridiculous defenses and trying to save their corporate money and not being accountable and not wanting to take ownership for their own actions. And so the other thing that we could do today, that was the I wanted to go through the settlement history, so we did that. But also, there is some footage of the trial, and there's 2 particular clips that I wanted to look at. We don't have to look at the whole clip, but we could look at some of it, and I could stop the clip and give some commentary. The first is the liability rebuttal in closing. So the way it works is that the plaintiff's lawyer gives a closing, and then the defense lawyer gives their closing argument, their summation, and that's supposed to summarize all the evidence that happened at the trial. It's the last time they get to speak to the jury. And then the plaintiff gives their rebuttal closing, which is the final closing in the entire liability trial. So let's listen for a little bit.
I have something else that I've never said to a jury before. This is the most ridiculous, frivolous defense I've ever heard in my entire career. This is insane. This is like something out of a law school book where you learn about frivolous defenses. We hear when people ask me what I do, I say I'm a civil trial lawyer. And they go, well, what types of cases do you do? And I say, well, I represent people that are seriously hurt. I represent families who have lost loved ones, who've had, somebody negligently, wrongfully taken from them against big corporations. And that's what I do, and I'm proud of it. And they go, oh, you're a personal injury lawyer. How about those frivolous lawsuits? And I say, I don't see that many of those, and I don't handle those. But what I do see is I see frivolous defenses. I see them time and time again. But I've never, ever seen one like this. This is insanity. And credibility is important. In the opening statement, I said, hold us to what we say. Hold us to what we say. My grandfather taught me, I grew up working on the farm, that be a man of your word. And credibility is everything. And if you're going to come and say something to somebody that's complete nonsense with a straight face, then you ought to not be trusted. Ever. Ever. It takes a lot to, build credibility. It takes this much to ruin it. They have no credibility. This is nonsense. This is frivolous, and you have to put a stop to it. You're the only ones that can, because obviously we can't. We can't. That's the power that this corporation has, and that these corporations in America have, to do whatever the heck they want, to victim blame. This is victim blaming 101, and they get away with it unless a jury tells them no. And you see what it takes to get to trial. And this young man has had the courage to stand up for himself, but it's all for nothing unless you stand up for him.
So you see what he's doing is he's empowering the jury. He's saying that you are the only ones that can make this decision, and it's about these frivolous defenses. he's going to go into the specifics, but it's about like blaming the dog and saying like, when we give you the cup, it's like on you, but how are you supposed to stop a falling cup? They're basically handing you a cup that's already falling. So it's kind of a ridiculous, frivolous defense. And he's empowering the jury and saying that this is kind of like the last bastion, the last hope, the last stand of justice. It's a really powerful emotional argument. And if you think about what's happening in today's society with companies like Uber trying to take away your Seventh Amendment Bill of Rights, your Seventh Amendment right to a trial by jury by saying, well, when you use the app, you agree to these terms, and it's going to be some fat cat arbitrator who's going to give you like 10 cents on the dollar, not a jury, because that's better for them, for their corporate interests. It just really shows that how we need to preserve our Bill of Rights and preserve civil justice. So it's a good argument.
I am upset. And what I told you about defense counsel, nice people, but that is not nice. But they're towing the corporate line and doing their job for the corporation, as they must, I suppose. But it's nonsense. Shift, 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 tilt, tilt, whatever. This doesn't fall if it's put in right. Is that theater, or is that common sense in putting this all into perspective? This is only put in 1 inch. It's not all the way in. We saw it yesterday, and it's dangerous, and it's going to fall, and it's going to burn the heck out of somebody and change their life forever. And that's what happened here. Burden of proof. The burden of proof shifts to them to show that Michael did anything wrong. And we asked their expert there, Han Lee of MIT. Han Lee of MIT, what did he do wrong? Oh, I wasn't asked to look at that. I didn't look at that. Why not? Because he didn't. They can't meet their burden of proof. They haven't proven that he's done anything wrong. They just want your prejudice and your bias and your speculation, but you won't give it to him.
Yeah, there was proof that I think they paid this expert from MIT like $70,000. And then he asked her, well, what did Michael do wrong? He's just sitting in the car accepting his drink that he ordered, or three drinks, because he was actually working for DoorDash. He was supposed to deliver it. He's actually helping Starbucks because he's delivering their drinks, these medicine balls. And so she says, I don't know, I wasn't asked to look into that. And then I think there was another part where he actually, we could do another video about that, where he cross-examined a corporate representative under like 30b-6 type principles. So a corporate representative kind of speaks or becomes the voice of Starbucks. And so he asked the corporate representative to actually hand him the cup. And she refused to do it because he put the cup in, only 1 inch, so it's like wobbling. And he said, well, hand it to me. And she refused. She actually pushed it down, and they said, well, now I'll hand it to you. He's like, no, what I'm saying is hand it to me like this. Would that be safe? And it was like the whole thing was just like a comedy, because she kept pushing it down and saying, well, now it's safe. He's like, yeah, that's my point.
You're good people. It's nonsense. They can't meet their burden of proof to show that he did anything wrong. Is this negligence? 1.4 seconds? This? And the whole dropping of the shoulder nonsense? That's just ridiculous. You've got his bicep, his arm moved and shifted. This went off. That should not cause this drink to spill. The only reason it spilled, and get this, you want to talk about corporate dishonesty? They have an expert that they pay $80,000 to. When he put her on the stand, asked her questions, and what question did he ask her about the cup? Did he ask her one question about the cup? He didn't. He didn't ask her a single question about the cup. It wasn't until my partner, Daniel Bittigary, got up and asked questions about that. Because her analysis, when she did everything, was the cup wasn't placed right. It was dangerous. And you'd think if she is this MIT biomechanical engineer with all the, experience, then why didn't she do testing to see, okay, if we fill a cup full of a hot medicine ball and we don't put it down all the way, what will it take to make it spill? She didn't do that? Why not? I'll tell you why not. Because the corporation didn't have her do that. With expert witnesses, we can say, you know what, look at this, but don't look at that. Test this, don't test that. We don't want you to test that because it spills that quick, that easy. Who did that analysis? John Bro did. And he goes, the tea bags in the water moving is enough to make it happen.
I'm going to skip ahead to the end of the closing.
Why is there this instruction? Why? Why would the judge give you this instruction? Who intentionally concealed evidence? Starbucks did with that video. We showed you when it was, we asked to produce it. Oh, then it pops up after his deposition. That's why you have this evidence.
Right, so what happened was they requested for production of surveillance video showing the incident, and Starbucks says we don't have it. Then Starbucks takes the deposition of the plaintiff, Michael, asks him all the questions about what happened, all the specifics, right? He testifies. Then afterwards, after they have his sworn testimony, then all of a sudden they find the video and they're like, oh, here's the video. And then now they were going to look for inconsistencies between what he said and what's in the video to try to be like a gotcha. You know, they do that a lot. Actually, I had a YouTube viewer call me. She had a case in New York, and the same thing happened to her. She was walking down the stairs. She fell. They said, there's no video. There's no video. But when she said, like, my foot hit, I think it was like a crack. Then all of a sudden they find the video. They zoom in. They're like, no, look, your foot did hit the crack. It's right next to the crack. Oh, come on. It's like these corporations are ridiculous.
Oh, boy, look at his deposition. And look at him. He was thin. He went through a lot that year. Doing his best. Start asking him questions, and he explained, he goes, I'm telling you, I tried to piece it together. It's like after an earthquake when people try to tell you how it all happened. But this was worse. This was worse. This was to the most vulnerable part of his body. And he said, listen, it was crumpled, everything was, he did his best. How dare they imagine a situation where you take a young human being who's gone through this and then start asking him with questions and then surprise him with a video that you've withheld, that the corporation has withheld all of that time. That's rotten, rotten corporate behavior. It's rotten. And it's rotten for defense counsel to then get up and toe the line and try to say, oh, look at his testimony and it doesn't matter, we have the video. That's rotten. And that should carry into the next phase of the trial, too, this lack of credibility we've seen. So, 100% against Starbucks. That is justice. Anything different validates and ratifies this corporate conduct and this bad behavior from what's supposed to be a good corporate citizen. No, clearly, it's all about the money. Defending this case the way they have. 100% against Starbucks. Yes to question 1. Yes to question 2. And then you don't even need to go down to 4 or 5 or 6. And you go home, and we'll see you on Monday. You did nothing wrong. And here's a really good instruction. Casey 411. He did nothing wrong. He had the right, under the law of the land, he had the right to rely on Starbucks. And if we want to talk about his experience doing all these deliveries, he knew how to get his drinks down on the floor. And he never had a spill and he never had a burn because everything was handed to him right and safely. And so with all of his experience doing Starbucks deliveries every day that helps this corporation make its money, they rely on these drivers. They make a killing off of these drivers. He had a right to rely on them to pass him a drink that was safe. And it was that experience doing it so many times that probably he made the mistake. He made the big mistake, and it's a mistake that we won't ever make, will we? Because now we've seen. He made the mistake of trusting the corporation to hand him a drink that was safe. And the corporation betrayed that trust, and they betrayed it all the way to today. And this is all for nothing without you. Thank you.
So that's the liability rebuttal closing, and then they won liability 100%. Now the next part, I think, is actually when he cross-examines that corporate rep. I think I saw that in here. We'll play that for a little bit. I think it's funny because she's, like I explained, she's the voice of Starbucks, right? You ask them to produce a corporate representative. It's federal rule of civil procedure 30B6. And then they produce a person, but they're not producing the person to speak in their individual capacity or their individual knowledge, but rather the person speaks on behalf of Starbucks. So these are Starbucks official policies, official procedures, official customs and practices, their habits, like everything, whatever issues he puts in the notice, they speak to the official position of Starbucks. So he is cross-examining her now at trial. She's also had a deposition, and he's just basically, well, you'll see, he was basically showing her the cups and asking her, so we can play that part of it.
You would agree with this. There's a right way to do things and there's a wrong way to do things, true?
Yes.
There's a safe way, there's a dangerous way, true?
Correct.
And when we're dealing with scalding hot drinks, we want to make sure we do things safely, true?
Any drink that Starbucks sells you, there's a certain way that you have to handle it, whether it's hot or iced.
Well, we're
And
talking.
it should be, specifically in this scenario, yes.
You want to be safe, correct?
In any capacity, yes.
Because if you don't put something in right and it's loose, it has a risk of spilling, true?
I didn't say that.
Do you agree with me that if you don't put something in right and it's scalding hot, that it has an increased risk of spilling? True?
No.
It doesn't?
No.
If you don't put something in right, so this one, that's in right, correct?
Yes.
That one, that's in right, correct?
Yes.
This one, is that in right?
Now it is.
Okay? And now it is. If it's scalding hot, is it safe?
All drinks seem to be secured in the cup holder.
If it's scalding hot in there, is that safe? Yes or no?
Now it is.
She keeps pushing it down and saying now it is, but that's the whole point, that they didn't do it. So it's kind of like silly. The whole thing is just a joke, like a comedy.
He wants you to answer the question when the cup is up in the air like
Is
this.
it safe now?
No.
And if it's filled with a scalding hot drink, that is at an increased risk of severely burning someone when it's put in that way, correct?
Correct.
You wouldn't allow someone to hand someone a drink like that, would you, if it's scalding hot?
It's not in the cup holder, correct, so no.
Because that would be at risk of causing that customer to be burned, true?
Yeah.
Okay. Please hand it to me.
Can you put the tray back down, please?
Sure.
Okay.
I know you want to put it back. I know. Thank you. I appreciate it. Do it like that. It's not all right. Scalding hot liquid in there. Will you hand this to me, or would that be against the protocol?
Well, the drink should be secured, and then I would hand it to you.
Thank you. All right. And why wouldn't you hand it to me if the drink wasn't secured?
What do you think?
Because
If the drink wasn't hot, if the drink wasn't secured, then it could potentially cause an accident.
now, I want you to assume something for a minute.
Okay.
It's like this. Okay? It's scalding hot. See the difference between the two? That's not okay, right?
There are not levels, so that is correct or not.
I want you to hand it to me anyways. I know you don't want to, because it's not safe and maybe you care about it. But I want you to hand it to me anyways. Okay?
Now?
All right, yep.
Okay.
Assuming there's scalding hot liquid in there. Now, if you handed it to me like this, and you let go, and there's scalding hot liquid in there, and it wasn't put in right, and now it spills within 1.4 seconds, you'd accept responsibility for that, wouldn't you?
No.
You wouldn't.
No.
Why?
Because I'm not sure like what would happen. How would I accept responsibility for something for that?
And isn't it Starbucks corporate policy that once your hands are off of it, it's on me, no matter what, it's my fault, if it spills and not yours?
There's nothing in our policy that states that I can recall.
Well, thank you. It's nice to meet you.
Yeah, so that was okay. That's the, and then we could do a quick one. We could maybe look at a little bit of the, now this is the damages rebuttal. So it's the same as we looked at in liability, but this is about damages, meaning what the case is worth and everything about damages.
Well, I don't want to get you mad, although if you are, you're justified, very justified. It's, anger is often a surface emotion. It usually is. There's something underneath it. And what's underneath anger, if there is anger, is sadness. Because the way that this corporation has treated this young man and handled this entire case, up until even right now, towing the corporate line, is sad. It is very sad. It's sad that a human being can be devalued this way. It's sad that, yes, these are frivolous defenses. Frivolous means without merit. It is sad. And it will continue to be sad until there's a just, righteous verdict. This thing about, let me see, is this up? No punitives, I agree. We'd be talking about billions of dollars. That's not what we're doing here. Not asking you to punish Starbucks. But this is the time for 100% civil justice. 100%. And it's clearly something that this corporation does not understand or doesn't want to understand. But it's time for full justice. So, what's going on there? This comment about the numbers, that is what this case is worth. That is what he is worth and what happened to him. That's 100% full justice. This is not putting, listen, if there are lawyers out there that might do what he's talking about, I don't. This is what the case is worth. The evidence and the law justify it. And 1,000%, if your verdict comes back and it's 125 million, you say that's what it was worth. That's what it was worth. Absolutely. It ruined a young man's life. It'll affect his family. It'll affect his future. Everything. Everything. He's got PTSD. It's forever. This is a forever injury. That's what it's worth. And when we have to look at 50 years and we have to forecast into the future what it is to provide justice for every single year for 9 separate items of harm that the law says must be included in the award, in the verdict, that's justice. It's not, you come back and say, well, it's half that. I'll say that's disappointing. That's disappointing. I'll honor and respect whatever it is that you decide, but that will be disappointing. That will not be a full just verdict. These frivolous defenses, he still got up here and said, it's diabetes. That's just ridiculous. So sorry that you've had diabetes since you were a kid, but the type of diabetes that he has, if he has a diabetic event, he goes in with his blood sugars. Does he look like a person? Do the medical records show that he's got peripheral neuropathy and all these different problems? No. His diabetes, it's gone out of control. But why? What goes with that? Depression and not eating right, which you heard from Roberta Falk. There you go. That explains it. It's not a problem that he had before. They did it to him.
So this is another example of a frivolous defense. So now we're talking about damages, and they're saying, well, all these injuries, this lack of feeling, this pain that he's having, this, that it's not from the burn, but rather from him having diabetes, which is very, very common. Like in let's say a case with a back injury, a herniated disc, somebody has a percutaneous discectomy, pain management, or an injection, or somebody needs like a full-blown laminectomy or fusion, they'll say, oh, this isn't from the crash, this is from degenerative disc disease. Here they're saying it's from diabetes. Very similar arguments. And he's asked all the medical experts, and they're like, no, this is not from diabetes. I mean, even I think the defendant's experts agreed that it can't be from diabetes. So it was kind of a ridiculous argument.
It caused him to have PTSD, and depression, and he has issues with eating, issues to where he can't even, he gets nauseous, and he's out of this courtroom. This is so tough. And then they want to blame him? Who was the expert that linked it up? Nobody worth a salt. It's just nonsense. It's just nonsense. But it's what the corporation continues to do. I guess he's got to do his job. In terms of friends, I actually consider you all my friends. It's how I am. I don't like what my opponent here, Steve Pelletier, has to do in this trial. He's doing his job, but I consider him a friend. I like him quite a bit. He got dealt a bad set of cards by this corporation when it came to this trial, but he's got to keep doing his job. Can't blame him for that. We all got to do our job. But consider him a friend. I haven't known him that long. And that's how I am. I'm from Iowa. We're friendly. It's called Iowa nice. Actually ran into one of the people that could have been on this jury the other day. I'm like, oh, so great to see you. It's just... Dr. Gazzaniga, and here's the spin. You listened. Dr. Gazzaniga, he kept trying to say, well, that's what's in the records. And I said, okay, answer my question. But it is true, correct? He'd say, yeah, that's true. It wasn't, well, it's true, that's what's in the records. He admitted, he had to acknowledge that everything in this case is true. That Michael's problems, they're real. That he had perfect functioning before, and then it's abrupt and it changed after this burn. That's true, right? He goes, yeah, that's true. There wasn't any, I mean, he tried to not answer the question, but his answers were stricken. He was forced to answer them. I wasn't asking him, this is what the record says. I'm saying these things are true. And he chose. Those are the things that he wrote down. I guess I had to make him eat his words, but he wrote down what he felt the pertinent medical facts were in Exhibit 5 of his deposition. He could have, I mean, there are all these medical records. These are what he chose to write down, but it wasn't what was in there that was true. It's what happened to this young man, and he had to acknowledge it. He said that this is what he deals with injuries like this every day. That's what Mr. Pelletier just said, right? He said, well, Dr. Gazzaniga, he deals with these injuries every day. No, he doesn't. He does not. That's completely untrue. He just made that up. It's not what Dr. Gazzaniga said. I deal with, injuries like this every day. He doesn't. He says I deal with, erectile dysfunction. But Dr. Goldstein got on in rebuttal and pointed out he really doesn't. He said some things that are medically incorrect. And he doesn't hold a feather to Dr. Goldstein.
So he goes through the medical evidence, and let me skip ahead a bit.
Body, his brain without PTSD, priceless. Priceless. So those dollar amounts that I've talked to you about, those are reasonable. Because what happened to him, and the way he's been valued, is very unreasonable. So reasonable has to match that which is unreasonable. Fair has to match that which is unfair. And justice, what is reasonable and not excessive, is that which is an equal trade for every year, for every item of harm that's been negligently inflicted upon his life and his brain and his body, his relationships, his family, his everything. And you can't blame the victim. They tried to do it before and they're doing it again. The autograft was impossible. You'd have to get skin from an eyelid. Doing an autograft, the xenograft, he talked about, oh, this wasn't an autograft case. The skin is so thin. How are you going to graft the head of a penis? Where are you going to get that tissue from? All you can do with an injury like this is graft it the way they did and hope that the body heals up. That's it. It doesn't mean that the injury's less. It means it's worse that you can't autograft it. Because of if it's skin here, okay, we can get skin to replace that. But where are you going to get skin for the penis? So thin. Skin for the head of the penis. Where's that going to come from? So they did the best that they could. Starbucks has the burden, the corporation has the burden to show that some medical treatment or therapy or whatever would have made his life better. But to suggest or say that, oh, because he hasn't got a whole bunch of medical care, that he's less injured or this is less of, a big deal to him, or it's just ridiculous. It's nonsense. If he had been going to the doctor or the therapist over and over again, you know what they'd be saying? Oh, that's excessive. That's ridiculous. He shouldn't be. He's darned if he does, darned if he doesn't, but there's nothing that can be done here.
So that's another example of blaming the victim, right? If you don't get treatment, they're going to say, well, you should have gotten more. But if you get treatment, they're like, oh, you're getting so much treatment, you're trying to orchestrate a false case, right? How come you're getting so much treatment? So it's like, yeah, you can't win with them.
Except the needle to the penis, which their expert, Dr. Gazzaniga, said, oh, he can get an erection. With a chemical in his penis, he can get a full 4 out of 4 erection. With a chemical and a needle being stuck in there. He said he wasn't calling and asking for help. Well, cries for help hasn't worked. But let there be no mistake, Michael is asking for help now. And I'm asking for your help. And help is the right thing to do. Help is the right thing to do. And only you can help. To hear the corporation's lawyer get up here and say, Dr. Goldstein is flat wrong, if there's an expert witness who deserves respect in this courtroom, who's done more for the advancement of sexual medicine and helping men and women, whose research led to Viagra, it's Dr. Goldstein. To get up here and say he's wrong, that's just nonsense. There's nothing Dr. Goldstein said that was wrong. Nothing. They're wrong. They don't understand, but you know, it's hard to get someone to understand when their salary depends otherwise. That's a saying. So, nope, they're not going to understand it. But Dr. Gazzaniga had to admit it all. He didn't like admitting it, but he had to. Reasonable is 100%. 100%, that's reasonable. Anything less than 100%, and no, they don't like those numbers. But they are real, and that is justice. And a $50 million verdict would be an injustice. That would be a win for them, and they know it. And they know it. That's why he made that argument. Oh, if you cut it in half. No, they know that's a win for them. They know it. But in this system of justice, civil justice, right? All people are equal. This is the one place where an individual can stand against a corporation. This is the place where there's equality. And the corporation is a person under the law, right? And they get equal treatment too. So, just imagine, what would they be arguing if it was one of their CEOs? Would those numbers be so unreasonable? No. Each of these items would justify. And here, imagine, someone came up, knocked on Michael's door that morning. He answers the door. How's it going? Michael, we have $10 million for you. He'd say, I didn't do anything. $10 million, really? Wow. So I could help my family out. I could do some things. He's someone who just loves to help others, right? Imagine the good he could do. He goes, yeah, but I didn't earn that. You must have the wrong person. No. It's $10 million just for you, Michael. It's for you. It's something you get to have. But we're going to take something from you. And we're going to replace it with grief. And you, for the rest of your life, 50 years, you are going to suffer from grief. You're going to grieve losing a part of you and the ability to do something it's very important. But you're going to get $10 million, but for 50 years, you will grieve. No, he'd say no. Nope. I don't want that. I don't want that. But no. Well, we're going to give you another $10 million for anxiety. We're going to give you anxiety for 50 years. Lifelong permanent anxiety. But you get $10 million. Say, I don't want that. I don't want anxiety. I've never had that before. I don't live with that. I don't want anxiety. Anxiety is, No, you're going to live with this for the rest of your life. It's called PTSD. You're going to have that. But you get $10 million. You'd say, no way. Get out of here. Slam the door in their face. So no. You're going to get another $10 million. That's for a separate item. Another 50 years. Lifetime of physical pain. When you touch your penis, stroke your penis, use your penis, it's going to hurt. It's going to hurt. Pleasure will become pain, but you get $10 million for that. No, I don't want that. Disfigurement. We're going to change the length and girth of your penis. $10 million. No, we'll give you 50. No, he would say. No way. Not that. Take my foot, right? Take an ear. Take my nose, for God's sakes. But not that. Don't hurt that. Don't know. The inconvenience of it all, the mental suffering. We're going to give you $10 million for each of these things. The loss of enjoyment of life. 50 years each. Well, that's $90 million. That's a number between $75 million and $125 million. That's justified. That's one way to look at it. You might find others. That verdict in that range is justified. 125 would be justified. And again, if it was someone else, I doubt they'd be arguing otherwise. It wouldn't be so unreasonable or shocking or excessive. It's so interesting that it's so shocking and excessive to Starbucks. Equal trade dollar value for each of the 9 separate items for 50 years. That's why this is justice, not reduced to present value, forecasting in the future and looking back if we go into the future to 2070, it's not unreasonable. It's full justice. Well, what we got here? Look forward to talking to you, whether it's at 4:30 p.m. today. If you have your verdict by then, it takes 9 of you. If 9 of you can agree, this could take a half hour. This could take 15 minutes. This could take an hour. This could take longer. If 9 out of 12 of you agree, then look forward to shaking all your hands. I'll be giving you a hug. Thank you.
So that was the closing. You could see what he did. He was talking about like this man with the briefcase argument that if someone comes and says, hey, I'll give you $10 million for each of the harms, would you agree to it? No, you wouldn't, right? You'd rather have your health, especially something like that, like your penis, your sexual function, but you don't have a choice. We're going to do it to you anyway. And that's what they did because of their negligence and their carelessness. And then now, instead of at least giving you the amounts, they're trying to say it's not worth anything. And then the other part was that he compared it to saying that, okay, they're saying it's not worth anything for Michael, but what if it was like, say, the president of Starbucks, right? The CEO, would they say the same thing? I don't think so. And it's kind of like getting close to the golden rule, which is if you said, oh, imagine if this happened to you, but you can't do that to the jury. That's not permissible because that's too, I guess, emotional. There's case law on that. There's precedent that you can't do that. But that's not really a golden rule violation because he's not saying, imagine if it happened to you, but he's saying, imagine if it happened to, like, say, the CEO of Starbucks. So it's kind of like an argument about different people being valued differently based on their status in society or their socioeconomic group they're in. So he's saying, like, look, this person deserves justice too. So it's a good argument for civil justice that it worked. There was a verdict of $50 million. Okay, Thank you, everyone. Please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see. We are here for you. Our goal is helping serious injury victims and families. If you need a consult, just text me. It's 347-566-9595. All the best, and we will talk to you very soon. Have a great day.